rise.
Just before you continue, I had on my draft an email from the law reporter at the ICLR asking if he could possibly have copies of the skeleton arguments. That's not been a problem. I don't think there's anything confidential in the skeletons.
We have not, well, there is, but we have non-confidential versions.
Good.
Oh, that's fine from that perspective.
Thank you.
My Lord, my Lady, I'm moving on to deal with the Tribunal's judgment, which is behind tab 9 in the core bundle. Paragraphs 1 to 12 are essentially summarising the procedural background, so starting with paragraph 13 on page 74.
Yep.
This is the Tribunal applying the same test for a new plea as in Royal Mail, so in our submission they're clearly directing themselves correctly as to the applicable test. Paragraphs 15 to 23 are then the Tribunal summarising the principles that are derived from Royal Mail. Paragraph 16, they rightly remind themselves at the bottom of the page that it's important not to read the words used by the Tribunal in Royal Mail as a statute. Paragraph 20, they rightly identify the need for a defendant to establish a sufficient causal relationship between the overcharge and the steps which are relied upon as amounting to mitigation. And they say, if a defendant can only point to what might be regarded as ordinary financial operations and budgetary controlled processes, this will generally be insufficient to establish the necessary connection between the overcharge and the relevant steps. Pausing there, in my submission, that's because these ordinary processes don't arise out of the breach in the way that's required by British Westinghouse. So what the Tribunal is not saying here, what they're not trying to do is to establish a presumption or a general requirement that ordinary financial budgeting processes won't suffice for the purposes of mitigation. What they're saying is they don't disclose the necessary causal connection between the overcharge and the relevant steps taken to demonstrate satisfaction of the causal relationship, and so they say you need to look elsewhere. You need to ask whether there are inferences that can be drawn from other matters. What they do go on to say is to expressly explain that they are not identifying the ordinariness of the transactions as being a sort of a presumption against mitigation. So they say this does not mean, as Mr. Harris's submissions at times.
Well, that's clear from that passage in paragraph 29, which I drew to Mr. O'Donoghue's attention.
In my
you read the two
submission,
together.
I'm grateful, my Lord. I'll move on in that case. Paragraph 21, they extract the principle from Royal Mail that there must be some basis other than pure theory for believing that a defence of mitigation has some factual basis for it. Paragraph 22, they identify the principle that relevant facts relied on must give rise to a plausible case of causation which carries a degree of conviction. They cite paragraph 43, which the court has seen. And then paragraph 23, they say it's possible for facts to exist from which a reasonable inference of proximate causation can be inferred, and then they cite paragraph 42 of Royal Mail, which is the one we looked at, which has the 4 possible examples in it. They then summarise the parties' arguments, 24 and 25, and their consideration of those arguments then begins at 26. In our submission, the Tribunal is right when it identifies the essential question in the present case as being whether the case advanced by NTN in its voluntary particulars pleads a plausible case of causation which carries a degree of conviction. And in our submission, the Tribunal is...
I suppose we treat plausible as the same as realistic, or just as Lewison's expression was realistic. I suppose realistic and plausible are interchangeable.
My Lord, yes. I think you can take it that they're applying the test that they've set out at 20, which I think uses realistic rather than plausible. We also say, the second half of this paragraph, that they are right to say that the question does not raise issues of law which are in the course of development, particularly bearing in mind the thorough and careful analysis of the relevant principles of law in Royal Mail. They say this present application involves considering how those principles of law apply in the context of NTN's pleaded case. And what the Tribunal then goes on to do is to set out what it's identified as the weaknesses of the defendant's pleaded case. And so paragraphs 27 to 28 is the Tribunal's summary of what it understands the pleaded case to be, focusing on cost targets and essentially proposition that it's relied on for at the end of 28, the consequence would be on NTN's case, if one particular input cost could not be reduced, attempts would be made to reduce other costs, and in this way, were there any overcharge on bearings, that would be mitigated by lower prices negotiated with other suppliers. So they've summarised the effect of the pleading, and then what they say in 29 is, we do not consider that these facts give rise to a plausible case of causation which carries any degree of conviction. There was no suggestion in NTN submissions that the setting of targets can be regarded as being in any way an unusual business approach. In our view, it is clearly not. It's an ordinary and run-of-the-mill budgetary control process. It was not introduced in consequence of the alleged overcharge, of which FCA knew nothing. As an ordinary budgetary control process which operated independently and in ignorance of an overcharge on bearings, the necessary linkage between that process and the overcharge is absent and certainly implausible, at least unless there are some particular facts which plausibly give rise to the inference that the necessary causal connection existed. So again,
The use of the word plausible actually comes from the cat in the Royal Mail case.
your lordship might be right.
Well, I think if you look earlier on, paragraph 14, 3, they say what is needed is some plausible factual foundation for the application of economic.
The wording could be relevant because in easy fare, I think the test is realistic and more than arguable. That's the test which the CAT has adopted. So it's not intended to be that low a threshold because arguability per se isn't sufficient. So plausible and realistic are in some respects beyond that. So one needs to be a bit careful with the language used.
Your lordship's right. If we look back at the way it articulates the test in 20, on page 77, you see there they refer to may nevertheless permit a defendant to establish a plausible case of causation, notwithstanding the ordinariness of the financial operations and budgetary process relied on.
Yeah.
And 13, the tribunal reminds itself a realistic prospect is one that carries some degree of conviction and is more than merely arguable. So your lordship is right that they are applying a threshold which goes beyond arguability.
Well, they seem to have equated realistic and plausible, really, don't they?
There is a certain extent to which they seem to use them interchangeably, but in my submission, certainly we understand there's no suggestion that they've applied the wrong test.
No.
So just going back to the wording in...
I'm sorry to dwell on this. I mean, the add-on, the caveat, it must be beyond arguable, puts it at quite a high threshold. In this is a case where one's balancing difficult rights of the claimant against difficult rights of the defendant. And Mr. O'Donoghue's right to say there is an informational asymmetry which a defendant faces. It's quite a high burden if not only do you face the informational asymmetry, but you've got to establish something beyond arguability. It may just be the consequence of the way the law has been developed over years. It's quite tough though.
I mean, Lord, the origin of the test is essentially the strikeout test. And so the reference to it having to have a degree of conviction is strikeout authority rather than... So they are, I think that comes from paragraph 20 Royal Mail where they said that. So they are not there applying any higher threshold than one would normally apply for a strikeout test.
Well, under the old law, it was good arguable case.
Yeah, that's true. 1819.3.
Under Order 14. I only say that because I remember Mr. Justice Bingham, he then was saying to me, when I said, well, my lord, I have an arguable defence. He said, Mr. Flo, of course you have an arguable defence. You're arguing it, but the question is whether it's a good arguable defence. Anyway, we've moved away from that phrasing to different forms of word.
Oh, yes,
I don't think Mr. O'Donoghue is suggesting that the tribunal applied the wrong test.
I certainly don't understand him making that submission there. And were he to do so, I would say that it's applying the correct test and it comes from the strikeout authorities.
Yeah.
I think we were just looking at paragraph 29, and I would just like to make the submission again that the tribunal is not here laying down a rule that an ordinary budgetary process will never suffice. It's saying that something that operates independently of a cartel is not going to give you the linkage, the causal linkage that you need. And what it then does in paragraphs 30 to 33 is to go on to consider whether on the facts of this particular case there might be some particular facts which give rise to an inference of a direct causal link, notwithstanding that you are, in this case, dealing with a normal budgetary process. It reminds itself again at paragraph 30 that, this is over the page, that one mustn't treat Royal Mail as a statute. And what it then does is go through and consider the 4 scenarios that Royal Mail identified as being examples, non-exhaustive examples of the sort of circumstances where you might actually get a causal linkage, and it finds that none of those are present in the circumstances of this case. And so 31, it's considering knowledge of the overcharge, and it says it's not suggested that FCA knew anything at the time about the overcharge. It was not therefore something the FCA would have been seeking to address. So that was the first point identified in Royal Mail. Second point, the gross amount of the overcharge as a proportion of FCA's relevant expenditure was extremely small. Again, therefore, it was not something the FCA would have been seeking to address. Just pausing there was some exchange this morning about how that could be in the circumstances and the relevant figures. And I understand that the overcharge, leaving aside interest, is of the order of 57 million over a period of 7 years of the cartel. But then the effect of the cartel goes beyond the 7 years because of the way in which procurement operated, such that you might have a contract which then extends for a further period beyond the period of the cartel. And so the overall period you're looking at is approximately 15 years. And so the overcharge per year is something in the order of 3 to 4 million in the context of a company that has a turnover in the billions. And so that is how the tribunal has been able to find as a fact that the gross amount of the overcharge as a proportion of FCA's relevant expenditure was extremely small. And so again, that indicates that there's no cost cutting in response to the cartel overcharge. It addresses the 4th criterion at the end of 31. There's no suggestion that other supplies made by NTN or its associates to FCA were renegotiated in years following the increase in prices. And then 32 is dealing with the 3rd criterion identified in Royal Mail, the relative ease with which the claimant's business could be expected to reduce certain input costs. And you can see the conclusion at the end of that paragraph. As it is, there is nothing in NTN's pleading or evidence which suggests that the reduction of FCA's input costs was relatively easy. And so having dealt with those 4 points, you then come to 33, where the tribunal says ultimately NTN can only point to the setting by FCA of benchmark targets for cost reduction. That's the extent of this case. And the tribunal identifies that the fact of setting benchmark targets gives rise to 2 possibilities. The first one is that those targets might have been missed. And if the targets are missed, then they wouldn't have mitigated the overcharge. And then the second possibility is that the targets might have been achieved, but then, as the tribunal says, if they were achieved, they weren't plausibly linked to the overcharge, where the overcharge was unknown, and it would have been achieved anyway as a consequence of the hard work of the procurement staff independently of the overcharge. And so again, in our submission, the tribunal is here asking exactly the right question. It's saying, are the matters that are relied on here arising out of the overcharge, or are they independent of the overcharge? And it's finding very clear that they are independent of it. Paragraph 34, the tribunal is commenting on the theory that setting targets could have led to mitigation, and it says that even that depends on unpleaded facts, which it describes as speculative and without any factual foundation. And the particular example that the tribunal is giving in 34 is the one that I've already canvassed with the court, which is the fact that procurement staff, the theory requires you to assume that procurement staff would only negotiate so far. They wouldn't negotiate as hard as they could. And the tribunal explains its understanding of this. It says, in particular, the argument assumes that procurement staff would not negotiate as hard as they could for lower prices, but would only do so to the extent required to meet the target. On this theory, as we understand it, the overcharge would be in practice compensated for because the existence of the target operated as an effective cap on the cost reductions which procurement staff were seeking. If therefore that cap were reached, then the achievement of the overall target would mean that the reduction in other costs would have compensated for the overcharge. And it goes on and addresses 2 points on that. It says, first of all, there is nothing in NTN's pleading or in the simple existence of a target as a benchmark which suggests that FCA's workforce would not negotiate to reduce costs as hard as they could, or explains why they would not wish to do so. And they point out, indeed, Mr. O'Donoghue in his submissions relied upon the sophistication and power of vehicle manufacturers as contract negotiators. NTN's implicit case that FCA's negotiators would not negotiate as hard as they could and would stop when they had reached their target because the target operated as a cap on what they were required to do or did is unpleaded and speculative. So 2 points there. It said, first of all, it's not pleaded, and secondly, in any event, it is speculative. And they go on to conclude, in our view, it is not a case which carries any degree of conviction at all. Rather, it is at best a speculative theory for which NTN are hoping to find support by way of their request for disclosure. This is not a proper and sufficient basis to grant permission for voluntary particulars to be filed. In my submission, the tribunal has dealt with this entirely effectively. They've identified both the problem that it's unpleaded in the first place and secondly the problem that there is no factual support whatsoever for the proposition, even if it were pleaded.
Well, I suppose you could envisage, couldn't you, I mean, I suppose the setting of the target in such a manner that to go below the target would alienate suppliers so that they would no longer continue to supply. So the company sets a target which it knows is basically the irreducible minimum below which nobody will go. Well, that's one thing, but I mean that requires evidence that that's what was going on, or at least a pleading to that effect. There's none of that at all, because otherwise, as the tribunal rightly says, why wouldn't the negotiators for this hard-bitten vehicle manufacturer just get everybody as low as they possibly could?
Why would they leave costs on the table when they could reduce them further? It is counterintuitive as a proposition, and as your lordship says, the pleaded case is very far from that. So, in the light of that, the tribunal then in 35 declined to give permission. And I'm turning now to address, hopefully relatively briefly, the 4 grounds in the light of what I say is the tribunal's correct approach in the judgment. Ground 1 was the contention that the tribunal erred in law by holding that ordinary financial operations and budgetary control process will generally be insufficient to establish mitigation. And the court has my submission that this is a mischaracterisation of the tribunal's judgment. The tribunal wasn't purporting to apply some sort of novel presumption or new rule that an ordinary budgetary process won't suffice. All it was doing, entirely conventionally, was saying that the defendants have to establish a sufficient causal connection between overcharge and mitigation. And then it duly went on to consider whether or not there were other facts which might give rise to that connection, and it concluded that there were not. That, in my submission, is a completely straightforward application of the test in British Westinghouse, and there is no basis for criticism of it. The defendant's argument that ordinary everyday budgeting processes can be sufficient to establish causation rests on 2 points. The first is the Supreme Court's judgment in Sainsbury's, and in particular that passing remark that the Supreme Court made that legal causation might be straightforward in the circumstances of that case. And we make 3 points in response to that, which the court will appreciate because they're the ones that I foreshadowed when we looked at the judgment in Sainsbury's. First, we say the Supreme Court wasn't considering this particular question. It was considering whether the broad acts principle applies to pass on as it applies to overcharge. And so one has to be careful in placing excessive weight on what was essentially a passing observation. Secondly, I've highlighted that the Supreme Court was assuming that the merchants in question were responding to an overcharge by taking various steps, and so therefore it was proceeding on the basis that there was the requisite causal relationship in that case, unlike this one. And thirdly, in my submission on any view, the Supreme Court was clearly not intending to depart from the requirement in British Westinghouse to show causation because it cited it. So that's the first basis on which it said, oh well, ordinary budgetary processes can suffice on their own. The second basis on
Sainsbury's bag, I think
maybe disagreeing with the submissions I'm making.
speaking from the side.
It's full of passed on products.
If the Sainsbury's bag will permit me, I was going to address Platt and London Underground. The submission was made there that that case demonstrates that you can reduce your damages without taking any particular step at all. And I've shown you that actually in that case, the court considered it was the same parties contracting in respect to the same kiosks under the same transaction. And so it looked at the overall damage suffered in that single transaction. It's not analogous to the circumstances of the present case at all. So in our submission, that addresses ground 1. Ground 2 is the contention that the tribunal erred in placing weight on the fact that the claimants were not aware of the overcharge at the time. And in our submission, this is clearly misconceived because it is self-evidently relevant to an inquiry as to whether a claimant took steps arising out of a breach, whether they were aware that they were a victim of the breach or not. And this is another ground where in our submission there has been a mischaracterisation of the tribunal's judgment. It didn't find that absence of knowledge of an overcharge meant that it was inherently unlikely that there would be mitigation or that there would be any realistic prospect of success. What it did was look at the defendant's voluntary particulars and find that those had no prospect of success. And it did specifically work its way through the potential bases identified in Royal Mail which might indicate a causal connection and found that they weren't there. Knowledge of the cartel is an illustrative example, but I showed you that the tribunal was very careful to direct itself that you shouldn't read Royal Mail as a statute, place too much reliance on it, didn't treat it as an exhaustive list. On a fair reading of the tribunal's judgment, it certainly didn't treat the absence of knowledge of the cartel as determinative. Ground 3, the defendants argue that the tribunal erred in finding that these matters were not an area of developing law. I have made the submission that the principle of the need for a causal link predates even British Westinghouse and is very well established. And the Supreme Court was merely applying well-established principles in a competition law context. And it even cited British Westinghouse in doing so. So this is not a new proposition that is being applied here. There was emphasis in the defendant's skeleton on the fact that no cartel damages claim has gone to trial and dealt with these issues. But in my submission, that's just irrelevant in circumstances where what we're talking about is the adequacy or otherwise of a pleading. And in any event, the fact, even if you can point to an area of developing law, we've cited a case which tells you that it doesn't mean that you can't nevertheless strike out a claim because it has no real prospect of success. Just to show the court that very briefly, it's Hudson and HM Treasury, tab 5 in the authorities bundle. The court looks at page 51. See at paragraph 50, the submission was made in this case that the law of restitution was a rapidly developing area of law. And so it would be wrong in any event to strike the claim out at this stage. And he cited Lord Justice Potter in Partco Group. That was the submission that was made to the court. If you turn to paragraph 59, see this is the beginning of the court's consideration of the power of the court to strike out a claim under CPR 3.4, with particular reference to Mr McCormick's reliance on the proposition taken from Partco that it's not appropriate to strike out a claim in an area of developing jurisprudence. 59 to 65 is a fairly extensive review of the authorities, and then you get the conclusion at 66 to 67, where he says, as I read these authorities, they do not in any way erode the well-established principle that claims which are plainly and obviously bad should generally be struck out. It follows that the proposition that it's not appropriate to strike out a claim in an area of developing jurisprudence cannot be an absolute one. Indeed, in saying that it would not normally be appropriate to strike out such a claim, Lord Brown-Wilkinson expressly acknowledged that there might be cases, even in an area of developing jurisprudence, which was so plainly and obviously bad that they should be struck out. If it were otherwise, the court's jurisdiction to strike out hopeless claims would be unexercisable in any case where the hopeless claim purports to invoke an area of developing jurisprudence. And in our submission, the tribunal was able to determine with certainty, and rightly so, that the pleading case had no real prospect of success at succeeding at trial because of the absence of a credible causal link, and that is not something that was going to change. Finally, ground 4 was the contention that the tribunal erred in finding that their defence and voluntary particulars should be struck out because it rested on unpleaded factual premises that were not supported by the facts. In my submission, the tribunal was clearly right to draw the conclusion that it did on that, and I've addressed the court on what we say they were. The tribunal will have seen the particularly striking example at 34 about negotiating down to lower prices. Mr. O'Donoghue's response at this point is to say, well, whether staff negotiated prices down to their fullest extent or not is a disputed question of fact for trial. In my submission, first of all, the court was quite right to put to Mr. O'Donoghue in this context that there is a need to plead an irreducible minimum before you get to trial. And Mr. O'Donoghue relied on the asymmetry of information. But of course the key question is, well, can disclosure rectify the fundamental failing in the pleading? Is it something that can be rectified? Is it the expectation that more information will rectify the situation? And in my submission, in this case, it can't, because there's no reason to think that further paper will disclose a causal relationship in circumstances where you've got costs measures which are operating entirely independently. So in my submission, the tribunal dealt with this point entirely correctly at paragraphs 33 and 34 of the judgment. Before I conclude, the court obviously granted expedition in this matter. I don't know whether it would assist the court to be updated on where we are in terms of timing. There was a pre-trial review on the 26th of November, at which an application to adjourn the trial was refused. So the trial is currently due to start with a reading week on the 10th of January, and then the trial itself starting on the 17th of January, for a total of...
My Lord, I'm sorry, there was no application to adjourn.
At all events, 10th of January reading week, trial starts on the 17th. That's as presently planned.
Well, it starts on the 19th.
I'm sorry, I should correct what I said. I understand that the point was raised in correspondence and then wasn't pursued at the hearing. I apologise.
So it wasn't pursued.
It wasn't pursued at the hearing, my lord, no. Apologise if that was unclear.
Okay.
So there is
In all events, the trial's due to start.
there's a trial due to start for a 6-week period from the reading week on the 10th of January. And I'm also told that there is a costs mitigation hearing in the trucks litigation, which is due to be heard in the CAT in early January as well, which will obviously be dealing with similar issues, and therefore it might be inferred would benefit from guidance from this matter.
No pressure then. Happy Christmas.
I'm sure we will be able to accommodate you.
And down tomorrow at 9:30. Not really.
Unless I could assist.
You think he's joking, don't you?
I hesitate to express a view.
Right.
Unless I can assist further.
Can I just wanted to ask, if I may, what is your answer to the two levers point that's made against you, that you have two sorts, you have the pass on and then you have the costs control as the two sorts of mitigation, and it's said that CAT has applied a lack of parity, I think, to each one. In other words, they're letting the defendants get ahead on the pass on, but they're unfairly limiting the ability to argue cost limitation. What would your answer to that be?
My lady, in my submission, there's no substance to that. In relation to both pass-on and cost mitigation, there is a causation requirement. satisfied in fact-sensitive ways depending on the way in which the defence is being advanced. But it's certainly no answer to an inability to satisfy the causation requirement in relation to this pleading, to point to different circumstances in relation with different potential defence.
Just coming back to this point as to where one strikes the balance, because words such as plausibility, realism, more than arguable, that they have an element of uncertainty about them. And Mr. O'Donoghue has made the point about the asymmetry of information, which is something which comes up in a number of different areas of law. And trying to understand from a practical perspective when a defendant is going to be able, if ever, if you're right, to plead a mitigation case in a secret price fixing cartel. Your answer might be that it's going to be exceptionally rare. It may be that if you've got a case like Sainsbury's, the industry was structured so that they would be passed on. It may be that you just looked at the industry and you could see that without much more than an ordinary business cost control system, there was going to be some element of pass on, and that would be sufficient. I'm struggling in my own mind to work out where one draws the line.
My Lord, I would certainly endorse what was said in Royal Mail, that this is going to be a fact-sensitive question in every case, whether it's available or not available. Royal Mail did grapple with this by identifying factors which they indicated might well give you the requisite causal link.
When you work through them, hard to see how they would operate in most price-fixing cases, collusive price-fixing cases.
The obvious one, which is knowledge of the overcharge, doesn't really arise in these sort of cartel cases, does it? I mean, that's the essence of it is it's secret. And as my Lord said this morning, the moment you learn what's really been going on, you issue proceedings and the whole thing comes crashing down.
My Lord, that's entirely fair. In my submission, it doesn't mean that the test is wrong, in the sense that the test for mitigation obviously requires conduct causally related to and in response to a wrong. And we've seen that going back to the British Westinghouse. And so if the circumstances of competition claims means that that's not going to be satisfied particularly frequently, well, that's a necessary consequence of where the law has drawn the line in saying you only take into account these matters when there is the requisite causal relationship.
I mean, the British Westinghouse test and the cases that Lord Buckingham refers to are nearly all, aren't they, cases of what might be described, well, they are all cases of overt breach of contract. So the cases where the claimant knows that there's been a breach of contract and takes certain steps to mitigate his loss in the light of that breach of which he's aware. This sort of case is a different, is in a very different factual context. And it might be said that Sainsbury's sort of fits into that mould more easily than other cases, whereas this case simply isn't in that mould. So I suppose your answer might be, well, it may be that they are going to be comparatively rare, but that's no reason for not applying the law as it's laid down by the House of Lords.
My Lord, that would be my submission, that the law, that the test is very, very clear. And if the consequence means that there are going to be relatively few scenarios where you can show that you have actually had a benefit as a consequence of your response to the cartel, well, so be it. That means the other side of the coin, of course, is what's being said is the defendant who has, on this assumption, caused an overcharge, can't point to matters which it has nothing to do with and for which it can't claim responsibility in any way at all, and say, because of those matters, my liability should be limited.
And can raise an entirely speculative plea, which, if it's allowed to stand, will lead to swathes and swathes of disclosure.
My Lord, yes, exactly.
Thank you very much, Ms. Ford. Thank you. Yes, Mr. Clark.
My Lord Manager, I can be relatively brief. Just to pick up on a couple of points just raised by the bench. In relation to Lady Justice Whipple's point on the divergence in terms of principle between the pass-on form of mitigation and the cost reduction form of mitigation. Ms. Ford, in my respectful submission, does not have a good answer to that question. And just to tee up the point, if we can go back to my pleading on pass on, which is in supplemental bundle tab 2, 166.
Yeah,
Tab 2,
page,
166, supplemental.
yeah.
So this is essentially a composite pleading. On pass on litigation, we said claimants passed on any owned overcharge to their own customers and purchasers. And that's essentially it. Now, in that context, it is common ground that in engaging in pass on, FCA had no knowledge of the cartel and nonetheless unwittingly passed on the loss in the form of a price increase. It is also my submission, or ought to be common ground, that in that context, the mechanism by which pass on was effected was simply to the ordinary budgeting processes of looking at costs, adding a responsive price increase if necessary. And those acts of mitigation are at least as independent in causation terms as the acts of mitigation we rely on in the context of the second form of mitigation. To put the point candidly, if they pass on the overcharge, nobody forced them to put up their prices. It was an independent decision that they made, looking at their costs and their budgets and so on. Now, the CAT's starting point in this case, I mean, I made this submission precisely and clearly, was that the absence of knowledge and the mechanism of ordinary budgeting were at least strong indicators or presumptions or assumptions or rules of thumb, call it what you will, which tended to suggest that the second form of mitigation was inherently unlikely. Now, except, of course, they went on to look at other matters, but that was certainly the starting point. And as I called it before lunch, the original sin. And we say that it is wrong as a matter of principle to suggest that knowledge and the mechanism and the independence of the mechanism would be irrelevant in the context of pass-on mitigation, but are potentially decisive, or at least of significant importance, in the context of input cost mitigation. We say there is no reason of principle why there should be that dichotomy. And indeed, one of the ironies of this case is that on pass-on mitigation, we served no factual evidence. That has been conducted through empirical and expert evidence. There was no suggestion that this plea before the court on pass-on was in any way defective. So Ms. Ford, in my respectful submission, has no good answer to why, at the level of principle, there should be this dramatically different approach between the two forms of mitigation. Second, on my Lord Justice Green's point on asymmetry, one important point in my submission is that the principle set out in easy, air, and related cases did not arise in situations of the extreme asymmetry of the kind we see in this case. And in my submission, when one is looking at the plausibility or realism of the pleaded case, one has to take into account the real world, which is, in a situation like this, it will simply be fortuitous that the defendant has any evidence in relation to how the claimant deals with input costs in the context of his business. Now, to remind the court, the only evidence we got since we were denied disclosure was some remarks in Ms. Whiteford's witness statement dealing with that in principle they have cost targets, that in principle they have a mechanism for monitoring them, and a small handful of specific documents identifying targets per vehicle. That was essentially an accident of this litigation. And to my Lord Justice Green's question, in the garden variety of these cases, the defendant will have nothing at the pleading stage. And if one goes to the CAT judgment at paragraphs 33 and 34, So one of the criticisms made at 34, for example, the theory that the setting of targets led to mitigation seems to us to depend on speculative and without any factual foundation in the material, in the evidence. But we have no evidence. And this is the chicken and egg problem with this judgment. The CAT says in the disclosure ruling, well, had we not struck you out, we would have given you lots of disclosure on the targets. But then when it comes to strikeout, the reason this is struck out is because there's no factual foundation in the material and the evidence. And with respect, the CAT cannot have it both ways. The starting point, as set out by the Supreme Court, 216, is that there is an extreme asymmetry of information. We do not know how they deal with non-bearing costs within their business. That is information exclusively within their sphere. What we have done, based on the only information we have been given, is identify a particular mechanism. I accept, my Lord, that there is some inference built on those acknowledged facts. But in the circumstances, faced with that asymmetry and a lack of disclosure, there was literally nothing else we can do. And the upshot of this appeal, if it is rejected, is that what the Supreme Court said in Sainsbury's under option 3, as being a defence in principle, in the context of competition damages claims in general, because of course, one of the fallacies of my submission and Ms. Ford's position, Sainsbury's was a case in which the European Commission intervened. It was dealing with competition damages generally and mitigation defences in the context of competition damages cases generally. It was not setting out some unique or different set of principles for restrictions of competition, which at some point were publicised. It was dealing with both categories of known and unknown restrictions of competition. And the upshot of the CAT's judgment, which Ms. Ford not only did not seek to deny, but in a bizarre way sought to aver, is that in virtually all of these cases involving a secret element, except by some accident of litigation, it would not be possible, because of the asymmetry, for any defendant to plead out a coherent defence. And the proof of that pudding is FCA's own bare-bones defence in the trucks litigation. I showed the court that before the break. It is lamentable by comparison with what we have pleaded. And if we cannot at least survive the strikeout stage, in my submission, except by some extraordinary coincidence, no one will. So a legal defence that in principle is available, according to the Supreme Court in Sainsbury's, will in practice never be available. That is a denial of the existence of the principle, and it is a failure to acknowledge the extreme asymmetry that underpins the problem. And in my respectful submission, that cannot be swept under the rug in terms of plausibility, speculation.
But just to be clear, on your analysis, you must be allowed to put it pejoratively, intentionally, to go on a fishing trip to see if there's a defence which exists, because you don't know at the moment, but you say you can't know. But because you can't know, you must be allowed to go on what they would describe as a fishing trip. That's the bottom line, because you say of the asymmetrical position in terms of information.
Well, Lord, I don't put it that high for reasons you will understand.
I'm not saying it's
Well,
wrong.
if Miss, and I appreciate your case is that she is, that if Miss Ford is right as to the correct analysis of the British Westinghouse principle, then that is, in a sense, how you have to put it. And if the tribunal's right that this is all speculation and not enough to satisfy the requirement of causation in British Westinghouse, then you are effectively saying, well, in cases like this where there's asymmetry of knowledge, I should be entitled, at the very least, to disclosure so that I can see if I can plead something better than I have done already.
Well, I'm not putting it that ambitiously. what we're saying in this case, fortuitously as it happens, it was common ground. They had targets. We had common ground. There was a system for monitoring costs.
But if you're wrong, if you're forced to accept Ms. Ford's proposition that pleading a theoretical construct will not get you home, aren't you then, I understand everything you say, but if, aren't you then forced to say, because of informational asymmetry, right to defend, so on and so forth, we're entitled to disclosure?
Well, at least in this case, I do not see it in those binary terms. Through the accidents of this litigation, we received some admissions and some documents. On the back of those, we responsibly pleaded this out as best we could with a statement of truth. I accept that in paragraph 6 and 7, we were then forced to rely on a degree of inference, building on those facts. So I don't put the case in those stark terms, well, we have nothing, therefore we should be allowed to go fishing. We have responsibly put in everything we could. And in my submission, it is a perfectly coherent mechanism. They're obsessing about costs. They have targets. We say they're hard-edged.
Again, we understand that. I'm forcing you to the proposition that if we don't accept that, are you then saying that you must be entitled to disclosure? You may be right, you may be wrong. We have to consider that.
Well, I'm not saying that. Of course, in this context, the seller and the buyer will have some relationship. That's why the litigation arises. Now, based on that relationship, as we saw Mr. Linate, he understood very clearly these people have incredibly granular information on costs. They're obsessing about costs. They're constantly auditing us for costs. And we reasonably inferred from those facts that the position in relation to other input suppliers is the same. These are general mechanisms in relation to cost reduction. So clearly the defendant has to do something. Turning up with a large, expensive, high specification fishing rod is not going to do the trick. There needs to be something based on the contextual relationship between the parties, some facts which in this case are common ground, which one can then reasonably infer certain things. So I do not accept this sort of hand-waving proposition that any old defendant can turn up with any old mitigation plea and then put the claimants to vast expense. Now, the other reason, of course, I don't say that is that in this case, we know from the disclosure ruling in paragraph 55 that the CAT would have given us disclosure on the targets, but for the strikeout. And one of the major distinctions between this case, my Lord Justice Green's point on effectiveness in Royal Mail, is that in that case, because all you had was an economic theory, not a single fact. Of course, in that sort of appalling vista, the disclosure looks horrendous. But in our case, no such issue arises because the CAT again found that they would have given us proportionate disclosure on the targets. And what we were looking for, certainly in the first instance, was modest. We asked for copies of instructions that the procurement people had sent to suppliers in relation to input cost reductions. But for the strikeout, that would have been granted. So this argument that the sky would fall, and this becomes a sort of charter for defendants to squeeze claimants on costs, certainly in this case, with this amendment in this context, that is not a factor. And I would entirely accept in other contexts where you have paragraph 30D of Royal Mail, where it's simply the theory and nothing else. I mean, they turned up without a single fact to make good mitigation point. They simply said, well, in economic theory, people seek to minimize costs. Well, so what? And the contradistinction with this case, that was a case where the CAT said expressly, it is pure theory, not a single fact. Here we have facts which are common ground and inferences built reasonably on those facts in the context of asymmetry. Now, my Lord the Chancellor fairly says, well, some of this in paragraph 7 is put in hypothetical terms. And in my submission, there are two responses to that. First, it is necessarily hypothetical because, of course, we deny the overcharge. That is our primary case. We don't need mitigation if there is no overcharge. And second, it is of course put in conditional terms, but if one goes back to the pleading itself and looks at paragraph 7, the bottom line is clear, and indeed is clear from the CAT's judgment. We say that these steps would have been taken and they would have led to a directly offsetting decrease in other costs, offsetting the overcharge. So ultimately, we say this would have netted off the overcharge. My Lord, it's the last sentence of paragraph 7. And of course, that is put in hypothetical terms, but the bottom line is clear. And the third point I would make in that context, what is envisaged in my submission is, whereas we say we have done, we have relied on factual material and pleaded that out with a particular mechanism as best we can in the circumstances. What paragraph 216 of Sainsbury's envisages is an iterative process whereby they would then plead back to the targets. We may have some initial disclosure, and at that stage, whether the amendment amounts to a row of beans could be challenged by way of strikeout summary judgment. We say what is wrong in principle is that we are cut off at the pass, or cut off at the knees. In the presence of asymmetry, there are tangible limits on what we can plead. And once we do that, it is said to us immediately, well, there's no evidence here. We say that that is a fundamentally unjust process. And it's not simply that it's unjust inter partes. It may well be that if FCA mitigated the overcharge and took other steps, that has a bearing on claims by other customers or suppliers. So in denying the possibility to NTN to say that in fact FCA suffered no overcharge, one consequence of that may be to deny or affect a potential claim by third parties who in principle under the compensatory principle would also have a claim. So this is not simply my respectful submission about, well, should we allow defendants to plead these mitigation defences. One has to bear in mind the compensatory principle, and it may well be that somebody else who is entitled to compensation has that compensation ruled out because of the approach to mitigation in this case. There's a couple of final points before I sit down. I mean, if one goes back to the CAT judgment, at 33, so I've made the point at 34 that they criticise us unjustly, saying there's no material in the evidence. Well, I say, what evidence? We didn't get any. But then at 33, and again, this is strikeout. So the CAT, in my respectful submission, tries to have it every which way. They say, second sentence, setting of the targets does not mean those targets were achieved. Might be missed, 1. 2, if they were missed, we cannot see how the setting of the target and the work by procurement staff to meet a target could have said to mitigate the overcharge. And then 3, if the targets were achieved, we do not see how it be plausibly linked to the overcharge in circumstances where the overcharge was unknown. And in my respectful submission, in the context of strikeout, it is simply inappropriate to determine each and every factual possibility decisively against my client in the absence of any disclosure whatsoever. Because my case is very simple. We say there were targets, they were hard-edged, and in circumstances where they were hit, because they're hard-edged, they would have stopped there. And that is why we say in the counterfactual, there is no loss. And what paragraph 33 in particular does is assume all of those factual possibilities against me simply by way of assertion. And had FCA put in a statement saying, well, in fact, here's a contemporaneous document showing our targets are never hard-edged, I would have been on a sticky wicket. What they've done is effectively determine a fundamental dispute of fact about the hard-edged nature of these targets against me on every possibility. And even on the narrower point about, well, is the causal nexus sufficiently proximate, or is it independent? In my submission, that is quintessentially a difficult and nuanced question of fact. And it is fundamentally wrong and unjust to determine that decisively against my client, effectively on the hoof, on the basis of say-so from FCA. In normal circumstances, we would be entitled to cross-examine a witness about the hard-edged nature otherwise of these targets, and to put to the witness what they would or would not have done in the counterfactual. These are all classical issues of trial. They will involve factual evidence, perhaps empirical fact evidence, perhaps expert opinion. And in the very same way as is occurring in this trial in January, in the context of pass-on mitigation, all these points can be put in relation to that form of mitigation. And yet in relation to the second form of mitigation, we cannot even plead or ask questions. So, my lords, my lady, in my submission, if we cannot plead what we have pleaded on a valid basis in the context of this case, it will be hopeless for any other defendant, save in the most extraordinary of circumstances, to ever plead on something that will pass muster. That is why I say that the principle set out clearly in Sainsbury's has been neutered and emasculated by the findings in this judgment. It is difficult to conceive of cases, except by accident, where somebody could meet the threshold. Lords, my lady, those are my submissions.
Thank you very much, Mr. O'Donoghue. Thank you very much for your interesting and helpful submissions. Despite the bravado exhibited by my lord, we will not be handing down judgment tomorrow. And we'll consider our judgments.
In our defence, we did not seek expedition.
Sorry?
In our defence, we did not seek expedition.
No.
Well, but you do want a judgment
And
in time to
the
consider.
reality is that we will do the best we can to let you have a judgment in good time for the hearings next term, but we won't make any promises because of other commitments. You'll get the draft judgment in the usual way for typographical corrections, not for inviting us to reconsider our judgments, please. And if you could endeavour to agree a formal order before hand down. If you can't agree it, then we'll deal with any consequential matters on paper in due course. But only remains to wish you all a very happy break.
Likewise, my lord.
I think we probably all deserve it, really, don't we? Thank you.
Court rise.